All right, great. I think we're recording now, and wonderful. At the start of class, I began with Usher, 2004. This was the #1 song featuring Ludacris when the Facebook was launched. You'll notice in Module C, there is a fascinating article in the Harvard Crimson. If you saw the movie The Social Network, this article is referred to in the movie. This is how I believe Divya Narendra, who is the business partner of the Winklevoss twins, this is how they find out that the Zuckerberg, in fact, has not been working on their website, the Harvard Connection, and has, in fact, it looks like behind their backs, has been working on his own website, the Facebook, as it was called back then. And it was launched on February 4th, 2004. And it really changed a history, probably, whether for the best or for the bad, I will leave everyone up to decide whether social media is a good thing or a bad thing, generally speaking, and whether Facebook, which now wholly owns Instagram, whether they are an ethically good company or in fact have done more harm than good. Now, rest assured, I'm going to come back to those big questions in the last week of this course when we do Module E and we look at Facebook today and we sort of take everything up to date. But here in this module and in this class, we'll be looking at the law of ideas. Now, before I do that, I do want to make a number of announcements. I need to be updating the syllabus because I'll be posting the guidelines for the final project, not in today's class, but at the start of next week's class, class number 5. It's a 3-page project. It's a very simple project. And I wanna actually cover this material before we open it up, as you'll be applying what we've learned. And so I'll be doing that next week. Also, I wanna mention back in Module A, when we talked about the Computer Fraud and Abuse Act and how federal law defines hacking compared to, let's say, various state laws and international conventions such as the Budapest Convention, I want to let you know that, and I posted it on the homepage of the course, that last Thursday, the Supreme Court handed out its decision in the Van Buren versus United States case, ruling against the government and ruling for Van Buren. This is a very important case because what it does is it brings us up to speed in that the Supreme Court is sending a signal that the idea of unauthorized use of a computer or use of a computer in excess of authorization, which is the linchpin of the federal definition of hacking, Supreme Court is sending now a signal to lower courts that this definition should be interpreted narrowly. Now, more importantly than that, for purposes of the survey course, that's sort of a technical issue dealing with the law of hacking. I think hacking is so important in today's business and legal environment that I began the course with face mash and the problem of hacking. But the more larger important point is that notice that statutes, laws, common law principles, and doctrines have to be interpreted by the courts. That's really one of the main roles of judges. In addition to resolving disputes and conducting trials, which you will see that in the next module next week, judges also decide questions of law, and they often have to interpret what the law means. And so that's why the Van Buren case is really important. It gives you a great example of what judges do on a daily basis and what they're paid to do. All right, I want to jump into the law of ideas. And let me see. I don't think there are any other important announcements in the home, but just go to the homepage. I've also been updating this day in history just to encourage people to go on the website and see things. And this is something new that I'm doing. I'm learning a lot about history as a history buff myself. So I hope the class is enjoying that. What I want to do, though, is I have presented, I think, just to make it, by the way, again, let me remind you, I've put in the chat the link to the survey, in-class survey for this class. And also, I've also included on the homepage of the course, the link, and you'll find it in Module C. The other assignments, the discussion post, we'll talk about that a little bit later. And the quiz will be entirely based on chapter 24 that I've posted in Module C, and then what I'll be talking about in this course. In today's lecture. So without further ado, let's go into the law of ideas or intellectual property rights. So let me do this. Let me go ahead and do a screen share And I just noticed, all right, let me pull this up. And I'm hoping this will be more interesting for everybody. And so let's go back to our thing. And I do have a couple of TAs, so they'll be monitoring the chat. So if you have any questions, I'm asking them to basically, address all your concerns, etc. While I give the lecture. All right, let's do a screen share over here. And now I have a lot of cool stuff in Module C, specifically relating to the founding of Facebook. So I'm going to go back today to the social network. I will tell you the Zapruder film, the home movie, the most important movie in American history because it depicts the assassination of John F. Kennedy. That involved a copyright dispute. I'll see if I can talk about that a little bit later. I'll definitely talk about that in the next module. There were some cases resulting over who owns the Zapruder film and whether you can copyright a piece of American history. But also, Tiger King involves a lot of interesting intellectual property issues, including the Big Cat logo and trademark infringement. And I think we have a guest visitor here. So we have my daughter, who's one of the perils of doing this. She can say hello, and I'm going to try to continue to push forward. All right. So we'll say hello to her, and let's move into the slideshow. And let's go ahead and do this. I'm going to play it from the start. Now, what I'm showing you here is the homepage of the Facebook, as Harvard students saw it on February 4th, 2004. And it gives you a great idea of intellectual property, great idea. If you build your own website or you come up with an idea for a website, or like in the case of Mark Zuckerberg, you steal an idea for a website, So I want intellectual property is really very important in the modern business environment. Now that we've cleared away and I've given you a big picture of the law, sources of law, like state and local law, federal law, such as laws enacted by Congress and international treaties. And then we did the common law, which is very unique to our Anglo-American legal tradition. Now let's jump into intellectual property law. And what's cool about intellectual property laws, you'll see throughout this today's lecture, it's actually a mixture of common law, federal law, and then even there's some international law, something called the Berne Convention. Now, we're not going to go into all the details. I'm going to provide you a big picture of the 4 or 5 main areas of intellectual property law. So let's begin here. And hopefully you'll find this as interesting as I do. I want to begin here with one of the great presidents, and that is, of course, Abraham Lincoln. And Abraham Lincoln was an attorney. One of the few presidents, I think Bill Clinton also, and I think President Obama both went to law school as well. And I think Joe Biden may have gone to law school, if I'm not mistaken. But Abraham Lincoln, I think, was our first president to be trained in the law. And by the way, he's the only president to have a patent in his name. But what's really cool about this quote is it kind of tells you why property rights are important from a philosophical perspective. You see here, property, the idea is the fruit of your labor. And now he's saying as a statement that property is something good, positive. Some might disagree. There's a famous quote by Joseph Proudhon, the French anarchist. He famously said property is theft, but Abraham Lincoln here in our legal tradition here, we're taking a different approach. And the idea is that property, the acquisition of property, while it may have some undesirable effects, right? Consumerism and materialism and environmental degradation. The idea is that property rights and wanting to get rich is sort of an incentive, that a motor of the economy. And I'm going to submit to you today that intellectual property rights are really important in the 21st. Like, I'm not going to waste your time. This is summer A. We don't have that much time, so I'm just going to cover the most important stuff. All right, so let's go ahead and continue here. But I just want to give you a little bit of a background here, and put this sort of in its perspective. Property law and intellectual property law, it sounds very intimidating, it sounds very technical. And to some extent, of course, it is, once it's codified in federal statutes and the common law tradition of cases. But the basic idea is that property, the desire to acquire property, the desire to, and the fruit, the desire to work to make yourself better and help your family and maybe your fellow man, that kind of thing, or fellow citizens, people of the world. That also has some positive effects as well. But let's go into from the legal perspective. And what's really cool, and then property rights, it's a big common law tradition, with real property. But what I want to explain to you, property rights also extends to ideas. Like here I have a number of products. I have a picture of my old house where I used to live on Jefferson Street. I have a picture. I don't have a Porsche 911 or Carrera, but it is a car. I love that car. My favorite car, sort of my dream. I have an iPhone, I think it's the iPhone 12, one of the newer models, the iPhone. I have an older model. But, take any product or take anything that you use on a daily basis. And this is why the law of ideas is so important, because any product embodies a set of ideas. And those ideas can be very complex and technological and sophisticated, like an iPhone. Those products can have those ideas might have even artistic elements, like the design of the Porsche 911 or the Porsche Carrera vehicles or the Boxster, etc. Or even an automobile, a set of blueprints. A house, a set of blueprints, and that also embodies a set of ideas. What property law does, it allows you to acquire ownership over an idea. And then property rights, the way the common law tradition develops it, is that once you acquire ownership rights, like we saw in Pearson v. Post, bright line rule, possession, or today, once you come up with an idea and satisfy certain conditions, then you have the right to use your property, the exclusive right, or to enjoy your property rights, whether they be ideas or whether they be physical things. This is very, very important, because this is how you can build a successful business just on a simple or good idea. Also, any income or stream of income or profits that your idea is able to generate, that belongs to the owner of the property right or of the idea. And also, via contract law, you can transfer those rights. This is what Instagram did. Instagram ended up selling out to Facebook. They sold their right. They created a group of entrepreneurs, created Instagram, and Mark Zuckerberg paid, I would say wisely, now that we look back on history, back in 2012, Zuckerberg paid $5 billion. He knew he couldn't steal it, so he paid $5 billion for the rights to Instagram. And what that shows you is that this is why intellectual property is such an important area of law, what I call the law of ideas, because you can either build your own business, or a business can expand by developing new ideas and asserting ownership over those ideas, property rights, or you can get rich or become successful by coming up with new ideas and licensing those ideas to third parties, to other companies, selling the rights to your ideas. So that's why this is so important, whether you're an entrepreneur or whether you're a business of any size, because all products and services embody ideas, and there's a whole area of law that allows you to assert ownership over your ideas. Now, I want to stop here to emphasize a really important point about this area of property law. It actually is something that I changed my own view of how the law works. Normally, when we think of law, like think of the Computer Fraud and Abuse Act, which makes it a federal crime to hack somebody else's computer. Or think of like, tort law, where, if your cattle trespasses on somebody else's property, you, the rancher, might be legally liable for your damages, for the damages caused by the cattle, depending whether it's a negligence rule or strict liability. Often we think of the law as something like, wow, I want to avoid the negative consequences, whether it be civil punishment, having to pay monetary damages to a plaintiff, or criminal liability, having to go to jail, pay a fine to the government. But also law has a positive or a constructive side, and that's intellectual property law. Intellectual property law is going to allow you to assert ownership rights over your ideas. That's why this is such an important area of law. So let me go ahead and continue with the slide presentation. Let's go back here and let me do a share. And when we talk about the law of ideas, and this is to give you a big picture of what I'm going to talk about today. I'm just going to introduce you to the main areas of IP law, what I call the law of ideas. You can see that there's four important there are four different ways that you can protect your ideas or the expression of your ideas, the way you portray your ideas. One, and they're here on the slide. That's what we'll talk about today. We'll talk about copyright. We'll talk about patents. We'll talk about trade secrets, and we'll talk about trademarks. So those are very important in the, I would argue to you in the legal environment, those are the most important, probably the most important area of law. Now, all of this is a mix of common law. All of these intellectual property rights originate in the common law. But remember Module A when we talked about sources of law, and I talked about Congress's power under the Constitution, to regulate commerce. One of the other clauses in Article 1, Section 8, and I'm sorry, I got landscapers out here, and totally bad timing. These guys started to set up right as class was about to begin. I apologize for that. Hopefully these guys will be quick. But one of the things that's in Article 1, Section 8 is that Congress has the power to enact legislation to protect the rights of inventors and creators to their inventions and works of art. And that's going to be, so what Congress has done is they've enacted legislation to protect copyrights and to protect patent rights. And then Congress has also enacted federal legislation to protect trademark rights. Trade secret law, however, as we'll see later, is still all common law, or about 95% common law. So it's a really nice mix. And even the federal laws that have been enacted over the years to protect patent rights, copyrights, and trademark rights, all those are based on common law principles by and large. So let's go ahead and jump in here. Now, what I want to do is give you some background, because I do want to go back to the social network. I think one of the unique things of the modern economy and social media and, internet platforms like Amazon, Apple, Google, is they're all built on intellectual property. So I'm going to talk about Facebook. I'm going to talk about Apple. I'm going to talk about Google. I'm going to talk about Amazon. Because if you think about it, these are the most important companies in our economy today. Now, of all those companies, only Facebook has a movie made about it, right? And that movie, I think, is a pretty good movie. So I'll be starting off with Facebook. Now, all right, let's see if these busters can just hurry the heck up so I could proceed with the lecture. What I'm showing you here, and I want you to appreciate, is that Facebook, look at all the different intellectual property rights that went into the creation of the Facebook before it was launched. Just put aside the fact that the idea was stolen. We'll talk about that later. But look at the source code could be a trade secret. It could also be copyrighted. Look at the bottom of the homepage. You'll see a copyright logo. We'll talk about copyright law. Look at the top, the Facebook, right? The color scheme. All that now is valuable trademarks. It's called Facebook, but it's all a valuable trademark now. The only thing that you don't really have here is patent rights. Now, I'll tell you, Facebook has grown, that they've actually bought out a lot of patent rights in their virtual reality part of their company. I think Facebook has the rights to, I forgot the name of the virtual reality technology that they've licensed, but I'll just focus on what the movie has on the founding of Facebook from Mark Zuckerberg's dorm room. Now, why don't we begin with what I think is the simplest, and I would argue to you the most important area of intellectual property rights. Oh man, these guys are killing me with this. At least they don't have the blower.
Professor, we can't
Trade
even
secret law.
hear.
Go ahead and check out this definition, and I have a couple of examples of two products that I use a lot that embody trade secret law. What I love about trade secrets, and the reason why I begin to buy trade secrets, is all common law, and you don't have to be a millionaire. You don't have to have, all you have to have is a good idea. Maybe you're the developer of famous Amos cookies, and you have a delicious cookie recipe. Maybe you're the developer of the WD-40 formula. Maybe you own a bunch of chili farm, and you have a recipe for your Tabasco sauce. Professor. Right? A trade secret is any idea. It could be a formula. It could be a method for developing a product. It could be it's any commercially valuable information. It's one of the most broad forms of intellectual property rights. If you have a good idea and it's commercially valuable, congratulations, you own a trade secret. You are the exclusive common law owner of your idea. Now, I have an asterisk because there's a bunch of cases, common law cases, saying that if somebody steals your idea and you want to go to court to protect your idea and to enforce your legal rights to your trade secret, you're going to have to prove to the judge that you took reasonable efforts or reasonable steps to keep your idea secret. By the way, I know that this is why Mark Zuckerberg, he does end up settling his case, as we'll see next week. But this is why the Winklevoss twins, whether you admire them as Bitcoin, crypto billionaires, or whether you despise them as a couple of preppy jerks who are accusing Mark Zuckerberg of stealing their idea, I'm going to tell you, let's be honest. Let's be completely honest here. Zuckerberg stole their idea. The problem is that when the Winklevoss twins, and we'll see this next week in more detail, when they try to sue Mark Zuckerberg to enforce their legal rights, how do you prove to a judge, that you took reasonable steps to keep your idea secret? This is a big problem for a lot of entrepreneurs, Let's say you go to a venture capital firm and they invite you to present your slide deck and you have some good ideas, but you say, hey, I want you to sign a non-disclosure agreement before I show you my idea. A lot of times people will laugh at you. Well, who are you? I'm not going to sign anything. Either you show me your slide deck or you don't. Or Zuckerberg and the Winklevoss twins, they're all in college. They're not going to be signing non-disclosure agreements. But this is why, a lot of companies, if you do own a valuable trade secret as part of your employment agreement and as part of any, prospective partnership agreement or investment deals, you generally want to get a lawyer to draft a watertight non-disclosure agreement or throw in a confidentiality clause into your contract with the other party, so that if somebody does steal your idea the way Mark Zuckerberg did, right, you can sue the bastard and get your money back and protect your idea. We'll see later, that this is going to be a close case because Zuckerberg stole the Winklevoss twins' idea, but the Winklevoss twins, as a matter of law, they're going to have a hard time proving to a judge, what were the reasonable steps that we took to protect our idea if, in fact, I don't have any non-disclosure agreements in my files with Mark Zuckerberg, so it's going to be tough, but you can see this is so important. If you have a family recipe, if you have an idea for a product or business or service, and it's, valuable, somebody be willing to pay money for it, right? You own a trade secret, but you have to prove, you have to take steps. You have to take, and again, it's an objective test. What would a reasonable person or an objective neutral observer, would they say that you took reasonable steps to keep your idea secret? The Winklevoss twins, I'll tell you, even though there's no non-disclosure agreement, in truth, they might still be able to pass the objective test, if only because according to their testimony, They only showed Zuckerberg their idea, the source code. They only shared the source code for Harvard Connection that had been pretty much like 90% already developed by their previous programmer, who, and the reason why he stopped working for them, the other guy, was because he got a job offer at Google, is because, but they showed him the source code only after Zuckerberg said that he was in and promised to work on the idea and presumably promised to keep it a secret, right? So it's not a frivolous case, but it is an uphill battle. All right, I want to show you what right now. Why am I showing you the Google search engine homepage? Probably the most famous homepage. The internet consists of billions and billions and billions of websites and pages and links and all kinds of stuff. I've just shown you the most, you're welcome. I've just shown you the most famous of these homepages, right? Well, the Google, I'm channeling my inner George W. Bush here, the Google, it's all protected by trade secret. Now I have included in the module C, Google's first patent, Larry Page, when he was a student at Stanford, pretty much like you guys are and girls. He came up with an idea. I won't go into all the technical specifications. It's really fascinating how the PageRank algorithm works. But the point is, and if you want to talk about it after class, I'll be more than willing to go into the details. It involves probability theory. It's really cool. He patented his initial idea back in 1998. And the patent is right there in Module C for you to see. But after he took his company, after he graduated from Stanford and then teamed up with Sergey Brin, and they set up their own company, and they bought back the patent rights from Stanford University, to whom they had assigned the patent. Everything after that has been protected by trade secret law. So look at this slide. Look at all the innovations that Google has made over the years. Beginning, after the initial Google search, and then they trademark Google, the trade name, and we'll talk about the trademark in the next unit, in the next part of the class. They developed the AdWords, kind of like a system for auctioning off advertising rights on the Google search page. Then they add Google Images way back in 2001. And then they add Google News in 2002, for example, Google Books in 2004. All of these developments, and I could go on and on, to the Google that we have today. My chart only goes up to 13. I ran out of space there. But look at all of these innovations, right? All of them are pretty much, Google has said, we're not going to patent this stuff. We're going to just go ahead and protect it as a trade secret. So what I'm trying to tell you is that trade secret law is pretty cool. If Google, the most powerful and successful, company on the planet, if now their business model is based entirely on trade secret law. And ask yourself this, why do you think Larry Page and Sergey Brin, why do you think the founders of Google, although they patented the original idea for the PageRank algorithm back in 98, why do you think that every other innovation since 1998, they've decided, let's just protect this stuff as a trade secret? Well, I'm going to tell you, it's not obvious, but I'm going to tell you, unlike a patent that would expire, like the Google patent of 1998, it would have expired in 2018. It would have expired, it's a 20-year. Utility patents or patents for useful inventions expire after 20 years. With trade secret law, as long as you take reasonable efforts to keep your idea a secret, and as long as your idea is commercially valuable, as admittedly the PageRank algorithm with all these innovations is, right? You have lifetime, indefinite, immortal. You have ownership rights. There's no time limit. The other advantage with trade secret law compared to patent law is there's no filing. There's no registration. There's no fee. There's no hassle. With patents, you have to do, we'll see it in a moment, you got to do a really complicated and a very expensive, time-consuming registration. Whereas trade secret, all you do is have a good idea and just keep it a secret. And if it's commercially valuable, you are good to go. You are the common law owner of your idea, of your trade secret. So a company, even as successful as Google, uses trade secret law. It's not just Tabasco sauce. It's not just the Coca-Cola formula. It's not just, It's not just, by the way, I noticed in my last video recording, for some reason, the share screen didn't come out. And when I had the share screen out, I was drinking my Coca-Cola, I thought secretly, but yes, I'm a big Coca-Cola fan, but it has to be in the bottle with me. All right. There's one pitfall, though, with trade secret law you got to be careful with, and it's called reverse engineering. Reverse engineering is a valid defense to a trade secret infringement lawsuit. So, for example, if you can come up with the Google PageRank algorithm and Google Maps and Google Books on your own by reverse engineering the Google website, if you can come up with your own formula for Tabasco sauce on your own, if you can come up with your own social network, the way the Instagram founders did, that's perfectly fine. Even though, you might end up copying elements of somebody else's trade secret. But if you come up with the idea on your own, then, that's totally lawful. That's the one risk with trade secret law. So trade secrets and patents, it's a trade-off. With patents, it's very hard and expensive to get a patent. But when you get a patent, you get it for 20 years. And there's no reverse engineering defense. It's your exclusive monopoly for 20 years. With trade secret law, there's no registration, and you have it for as long as your idea is kept secret. But you do run the risk that there's a possibility of reverse engineering if somebody smart enough can come up with your idea independently.
Why wouldn't a company like Google just do it?
I don't know if there's a comment over there.
Yes, Professor.
Yeah, jump in, please.
Why wouldn't a company like Google just get a patent just so that there is no risk of reverse engineering?
Yeah, it's a trade-off. Because with a patent, and you'll see it in Module C when you look at Google's first patent, you've got to share, you got to explain what's called the prior art and how your patent works, how your idea works. You actually have to explain it, and then after 20 years, it's available to the public, Anybody can basically copy your idea without any, legal liability. With trade secret law, yeah, you do, open yourself up to a reverse engineering risk, right? That somebody else that's as smart as you are or smarter can come up with the idea based on their own brain power, But the thing is, I think I'm going to answer your question. I think the founders of Google, they must figure out that their Google search rank algorithm is so complicated and has so many moving parts that there probably isn't anyone that smart to come up with it on their own. You know what I mean? Think about Bing, right? Microsoft, right? That's like, after Google, that's the most powerful company. And before Google, that was the most powerful company, technology company in the world, right? And I'm going to be honest with you, right? If any of you have used Bing, right? It's not bad. But compared to Google, it sucks. I mean, Bing is just not as good in giving you the good search results. It's not bad. But Google is so advanced that even the guys at Microsoft and the people at Microsoft can't make a search engine as good as Google's. As good as Bing is, it's still not as good as Google. So I think it's just a calculated risk. And this is where law and business intersect. It's really a business decision when you to decide, how do you protect your ideas? Do you go with patent law or do you go with trade secret law? The other problem with patent law, the fact that it's going to expire automatically after 20 years, is that 20 years, that's if you're lucky to get the patent. As you're about to find out in the next part of my lecture, it's actually very hard to get a patent. I used to, when I was a practicing attorney, I've always wanted to teach, but I got to work with some New York law firms on patent law. We were local counsel in Puerto Rico to some big companies like Upjohn and some other companies. And one of the things I learned about patent law that I didn't realize, as when I was taking patent law in law school, is that patent law, when you try to apply for a patent, you're always gonna get denied. The patent office's position, their default position is that your idea. Well, let's look at patent law, and let me explain why it is so hard to get a patent. So let me do a share screen again, and let's go into here, and let's see, what do I do? Oh yeah, share right here. So Now, there's different types of patents. I'm going to focus on what's called utility patent, which is what we normally think of when we think Thomas Edison, you know, or whoever came up with the paperclip. You know, you have an idea and you want to patent it instead of getting a trade secret. You know, think about it. Think about you're the first guy to invent a paperclip. You know, once you know, how can you keep that a secret once you sell your very first prototype, right? Your first batch of paperclips. Everybody's going to see what your paperclip looks like. And so there it makes a sense to basically use patent law and at least get the 20 years protection. You know what I mean? But with the Google PageRank algorithm, because, you know, even if you're smart, even if you're at Microsoft and you know about internet search, it's still not obvious why it is that Google is so good. You know, all these innovations they've done. So maybe you could go ahead and protect that as a trade secret and get more than 20 years and take the risk of reverse engineering. So let's focus on utility patents. But I do want to throw out there that there are other types of patents. The design patents are for ornamental features of a product. Those patents are much easier to get and they only last 17 years. And plant patents, I'm really feel bad that in a survey course, I can't go into any more detail. But I want to let you know there's a third type of patent. And to me, what I find fascinating about plant patents is think about artificial intelligence. If you're a big fan of science fiction, like I love Blade Runner 2049 and the original Blade Runner movies, could you get a patent right to a life form, you know? And it turns out that the Supreme Court decided this case in 1980, saying that, yeah, if you come up with a new way of, creating a hybrid plant, you can go ahead and patent that. And then subsequently, Congress created this patent, this plant patent. But let's focus on the main type of patent, which, and by the way, that raises a really deep moral issue. Can you patent life forms? You know what I mean? Biological life forms, you know? That's a really controversial question. Can you patent part of the human genome or genetic codes, you know? A lot of pharmaceutical companies have actually patented, and this is very controversial. But let's talk about utility patents and just your basic useful invention. Now, to get a utility patent, and now here's some examples of comparing a design patent. So the Apple iPhone, I thought I had my phone here, but you see there the image, the rounded edges, right? That is Apple has a utility patent for the design of their iPhone product, you know? There was, you may have heard a few years back, a very famous case with Samsung, because the Samsung Galaxy also had rounded edges. And so the question is that an infringement of the design patent? By the way, the jury ruled that it was an infringement, and I believe awarded to Samsung, to Apple, I don't know how many hundreds of millions of dollars. But let's focus on the utility patent when you have an idea for, for some kind of new product or service and you want to patent it. Let's say it's like a paperclip that once you sell it, it'll be easy to reverse engineer. Then it makes sense to patent it, right? As opposed to you rely on trade secret law. What I've done here, just given you sort of a summary, why it's so hard to actually get a patent. And there I have a part of the PageRank algorithm patent there. You have to prove that your idea, you have to prove three things. Remember, compare this to trade secret law. Trade secret law, all you have to show is that your idea is commercially valuable, right? That somebody would be willing to pay money for it. And you keep your idea secret. You take steps to protect your idea, generally by getting non-disclosure agreements or confidentiality clauses in your contracts. To get a patent, you've got to show three things. And this, I'm telling you, is really, really hard. You got to show, but by the way, what I like about this area of the intellectual property law is whether you go with trade secret law or patent law, or whether you decide just to do your own thing, this is a good test for how to come up with a good business idea or a good idea for a business like Shark Tank. Like, think about it, right? I'm Shark Tank. I'm Mark Cuban. I'm the other guy, the bald guy, I'm the one of the ladies. Am I going to invest in your idea? Well, look at these criteria. Is your idea new? Are you the first one to come up with it? To get a patent, you got to be the first one. You got to be the first one. And I'm telling you right now, that's hard. That right there kills 99% of all patents applications. Also, your idea's got to be useful. Like, you know, your idea has to be a good one. You know what I mean? And then finally, and this is actually probably the hardest of the 3 patent requirements for utility patents for traditional inventions protected by patent law. Your idea not only has to be good, useful, and brand new, it's got to be non-obvious. Your idea has to be something that nobody else could have come up with just by thinking about it. If you think about it, that is almost impossible to prove, because if you came up with the idea, at some point it has to become obvious to you, right? You know, but how come it became obvious to you and not to nobody else? That's really hard to prove. Suffice it to say, the only way you're going to get a patent is if you hire a patent attorney. And look, I invite you to look at Google's first patent in Module C, and he or she will help you explain to the patent office how you get, you know, why your idea is not only new and useful, but also non-obvious. How it is that nobody else could have come up with it except for you, you know? That to me is almost a paradox. How do you show that? If you look at that Google patent in Module C, what you're going to see is that getting a patent, applying for a patent, and then your actual patent that's issued by the United States Patent and Trademark Office, it looks very much like a scientific paper. It's a very technical, very sophisticated document, you know? It's a PhD level, you know? It's hardcore. And I'm not talking about like, history PhD or English literature PhD. I'm talking about engineering and science hardcore PhD level, you know? So it's a really tough to get a patent, you know? And oftentimes it can take years to go through the patent application process. That's the other reason why a lot of companies prefer just to use trade secret law and run the risk of reverse engineering. Because why am I going to spend all this money, run the risk of my application getting denied, and even if I do get my patent accepted, you know, and approved, I'm only good for 20 years, that kind of thing. All right, now you've seen the 2 main areas of intellectual property law and how you protect your idea. You can protect your idea either by a trade secret, the common law, you know, or no registration. You just keep your idea a secret. And as long as your idea is commercially valuable, as long as your idea is a good one, people would be willing to pay money for it, your idea is legally protected by common law. Now, that means you're going to have to use state courts to enforce your rights, you know, generally speaking. With federal patent law, you know, you've got to go through a whole patent registration process and prove to the United States Patent and Trademark Office and the patent examiner that you're assigned why your idea is new, useful, and non-obvious. Now, what I want to do in the last part of the class is talk about how do you protect not your idea, but the branding of your idea. You know, how do you distinguish yourself among consumers? You know, like, you know, even if you've never used Bing, or maybe you don't believe me that Bing is not as good as Google, at least the last time I used it. I try not to use Bing. But you know, why is it that most people still use Google? And in fact, think about it, all of these famous logos here and brand names, what they all have in common is that they're the most, even the Olympic logo, you know, they're all valuable trademarks. They're all valuable trademarks. And what that means is only the owner of that mark can use it to distinguish its products or services. So Google, right? Google search rank algorithm, page rank algorithm, they have the famous Google name and logo. Coca-Cola, you know, I love the Coca-Cola. I love the Mexican Coke. Huge fan, you know, the natural sugar. I love the bottle, you know, Coca-Cola, famous trademark, you know. In reality, Pepsi really tastes better, but the Coca-Cola trademark is so famous, you know. Look at all of these products, you know, and services. So, and I believe in module C, yes, I've also included the trademark application for the Apple trademark, you know, right, which you see right there on the right-hand side. One of the most famous trademarks ever. And what you're going to see about it, it goes back all the way to 1979. One of the cool things about trademarks is that if you register your trademark, even though your protection is only for 10 years, you can get automatic renewal as long as you're using your trademark in business, as long as you're using your mark in commerce, as long as you're selling goods and services with your logo, with your name, with your trademark. So that's really one of the nice advantages of trademark law, that for all practical purposes, it's, it can last forever as long as you're in business. Now, let's talk a little bit more about trademark law. But the reason why I wanted to show you this is to me, trademark law and trademarks generally, it's one to me, I think of trademarks as sort of like, I think of them as works of art. I think of them as such beautiful things, whether it's the Apple logo or the Nike swoosh, the McDonald's golden arches, the Olympic rings, these are just beautiful creations. So let's go. How do you get a trademark? Well, first of all, what is a trademark? Well, I just showed you. A trademark is basically it's anything that distinguishes your products, your goods and services from your competitors. So I want to give you an example. It says here a symbol like the Nike swoosh or the golden arches or the Facebook like. That's also a trademark now. Word or words, so the word Google, the word Apple, the word Tesla, in addition to the logo, can be trademarked. Also, by the way, colors can be trademarked. So UPS, the famous, one of the largest delivery, overnight, delivery carrier companies, right? They have trademarked what they call UPS brown. So the color of the UPS delivery trucks, they're the only company in the world that can not only use the words UPS and the UPS logo, but they can only use that brown color for their vans. For the ladies out there, those beautiful and completely, you see them at the nightclubs, the Louis Vuitton shoes. My wife, to my chagrin, has a couple of pairs of, the red bottom shoes, Louis Vuitton, Christian Louis Vuitton, they've trademarked that color. So only the Louis Vuitton company can use a red bottom for their shoes, because that's how they distinguish their shoes. So it's a really special area of law, very, very special area of law. And clearly in marketing, when what you're trying to do, I know we have a bunch of marketing majors. And in fact, if I'm not mistaken, from my week 1 survey, we had a lot of accounting and finance, but I think marketing edged out everybody in terms of the plurality of majors. If you're marketing, you want to be able to trademark your brand and your branding designs and stuff, because then your company, or you, if you're the entrepreneur, you own the legal rights to your brand. That's a huge deal, So let's go ahead. How do you get a trademark? Oh, by the way, one more thing is, here's the deal. Now, I want to show you this because there's kind of 2 types of trademarks: unregistered trademark and registered trademark. Whether you have an unregistered or registered, the definition is the same. The difference is that with an unregistered trademark, your rights are based on the common law. With the registered trademark, you've registered with the USPTO, the United States Patent and Trademark Office. You've gone through a trademark examination. And now the only difference is this: your rights are pretty much the same, but with a registered federal trademark, now you can go into federal court to protect your rights. We'll see. That's going to be next week why that's a big advantage. But I'll tell you just right now, to not keep you waiting, or in case I forget to say, federal courts on average are a lot faster in handling cases. And federal judges are a lot stricter with deadlines and stuff like that. So, and federal courts, generally speaking, are very much, generally speaking, pro-business and pro-intellectual property rights. So it's a lot, I'll give you an example of this. I remember when I was a law clerk, when I was still in law school, I was at the public defender's office and at the state attorney's office in Dade County when Janet Reno was in charge of the state attorney. Then I also worked at the public defenders as well. And I remember most of our cases, most crimes are state crimes, local crimes. And I remember going to the Dade County Courthouse, the Miami State Courthouse, and it was literally a zoo. It was just so full of people. It was just so, it was just the dockets were so congested. The judges were dealing with literally dozens of cases, in a single session, Then when I'd go over into federal court, sometimes we'd have a federal case, or I got to go be an observer to a federal case. Federal courts, man, like I got to see the Noriega, when Manuel Noriega, when the President George H.W. Bush, I think illegally arrested the guy and brought him to charges in Miami. But let's not talk about politics. Let's not talk about international law. When Noriega was put on trial in Miami, I got to go to the trial. I'll never forget Judge Hovenkop. But that, like the federal court was like the Ritz-Carlton of courthouses, There were just so fewer cases. The judges were such a tight ship that they ran, it was just a whole different ballgame. So we'll talk more about federal and state courts in the next class. Now, how do you get a trade? Wait a minute. Where is my thing here? I'm missing a slide. I apologize. Before I go into copyright law, let me do this. Let me go into the survey. In the survey, and I apologize for this. This is my bad. I must have deleted or not saved properly. Let me show you how you get a trademark. That's really, really important. Let me show you how you get a trademark. So let's just go ahead and go into the, just bear with me for 1 minute here while I do a time check. And then what I'll do is I'll conclude with copyright law. But this is really important. And so I want to show you how you get a, I'll just go into the survey. And I'll go into the, go into quizzes here really quick. And I'll do a, I'll go ahead and do a, where is this? Where are my, let me go, just give me 1 second here. I'm completely fumbling. All right, let's go ahead and go survey statistics and let me go find the share now, screen share. Good thing I had this backup slide, and because it's actually very important. If you go back to the slide I showed you, what do all of these things have in common? They're not only valuable, in most cases, registered trademarks, they're also very unique. And so if I just skip over to, if I'm in the share screen now, if I just skip over to this survey result, and let me just focus before I look at the actual results, let me just show you. Oh God, why won't this get bigger? All right, let me just show you this. What type of trademark was the Facebook when Zuckerberg launched it? Let me tell you, as early as April of 2004, Savarin is filing a trademark application for the Facebook. Now that's going to be mooted because they're going to drop the and then it's going to become called the Facebook. But originally, could you trademark the Facebook or Facebook? And that's actually an interesting legal question because to get a trademark, you have to be your mark, logo, color, symbol, word, or words have to be unique and distinct. Generally speaking, they have to be arbitrary, like Apple. Apple to describe computer products, it's completely arbitrary, fanciful. Google to describe search, internet search, completely arbitrary and fanciful. Exxon, Kodak are other traditional examples of an arbitrary or fanciful trademark. Or your mark could be suggestive. The examples there are Tide and Coppertone. The idea there is, Coppertone is suntan products and Tide is laundry detergents. You're suggesting what your product does. Descriptive marks and generic marks, however, as a general rule, are not trademarkable. And that's not a word lawyers use, but I'll use it here just for lack of time. You can't get a trademark if your mark is generic or if it's just descriptive. The only exception, like Holiday Inn or American Airlines, that kind of thing, or all brand, is when, and the courts, this is a common law concept, is if your descriptive mark has a secondary meaning in the minds of consumers. So today, for example, 2021, when you hear the word Facebook, There's no doubt about it, 100%. There is a secondary meaning that now when you hear the word Facebook, you're thinking of Mark Zuckerberg and the Facebook, you know? But back in 2004, when Usher's song was the #1 song, you know, Harvard already had a bunch of Facebooks, right? Each of the residential colleges, the houses, right? The Harvard, the houses like Kirkland House where Zuckerberg lived, they all had their own separate electronic Facebooks. You know, when I was going to school in the 90s at Yale, Yale had Facebooks. They were not electronic. They were physical, like little books, you know, with people's pictures on it, face pictures on it, face shots, you know? So it's kind of like, to me, ironically, I don't know if Mr. Zuckerberg could have trademarked the Facebook, you know, back in 2004. It's still descriptive and there's no secondary meaning yet. However, I have to say this is actually a very close question, because if you think about it, right, I showed you the original homepage. Remember, it was called The Facebook and it was one word. And when people use the word Facebook, they were really talking about the house websites, you know, that had the faces. So maybe the Facebook, one word, maybe you could get away with saying that's suggestive. I just want to show you, let's look at our student results here. Notice 31% saying it's suggestive. 32 though are saying it's basically a tie, saying it's descriptive. Some are saying it's arbitrary and fanciful. I don't know if back in 2004, if just by adding the, it becomes arbitrary all of a sudden. You know what I mean? I don't really know about that, but it is a close call. Some would even say generic. I think you could make a strong case that back in 2004, Facebook is a generic concept to refer to college Facebooks that already existed at the time, as opposed to the social media Facebook that Zuckerberg would steal and then develop, right? That would later go on to have a descriptive meaning. The main purpose of this survey is not to show anybody up. You get full credit for whatever answer you give, but just to show you that sometimes the law can be a close call. And that's why we have judges. That's why we have juries. All right. By the way, the other survey question I have here, a fun one, is Google generic? Look at this. Look at this. I'm going to forward this to Larry Page and Sergey Brin. 90% of the class, and I tend to agree, Google has become generic. This is an irony, right? Although when Google started in 1998, it was a completely arbitrary term, because the word Google has nothing to do with internet search, you know? But today, because when we use the word Google, we really mean internet search, regardless of what search engine we're using. I think a strong case can be made that Google has lost the rights to use the word, to exclusively use the word Google. Now, by the way, this is going to take me to my next area of law, my last area of IP law, which is copyrights. Because even when you have a generic trademark, or even when your trademark has become generic, guess what? If you can copyright your logo, even if other people can use the word Google to refer to search without any legal consequences, they still won't be able to use your logo. Or think of the Tabasco formula that I showed you, the Tabasco sauce, which I love. Like, I use Tabasco when I'm having breakfast. I use Tabasco on my salad. I use Tabasco on my Bloody Mary. I use Tabasco for a lot of different things. And or think of the WD-40 that I showed you earlier. Even if you're able to reverse engineer, the Tabasco sauce formula or the WD-40 formula, the Tabasco sauce company and the WD-40 company, they're still going to own or even if those terms become generic, like Tabasco to refer to any type of hot sauce, or WD-40 to refer to any type of a oil or grease product, guess what? They're still going to own the copyright, the look of their logo, you know? So this is why, so let's go with copyright law. And by the way, let me share the first survey question. It's really interesting here that only 18% said that you've created intellectual property. Let me just share something with you. In fact, as a matter of fact, without knowing it perhaps, you probably created intellectual property earlier today. You've definitely created intellectual property within the last week. In fact, I can say with 100% certainty that everyone watching me today and everyone in the class, if they're still alive, if they have a pulse and they have an iPhone, for example, or a phone, they probably have created intellectual property. And let me explain. And this is so important. Let me just go to the big screen here and explain why. Because copyright law. Even if you don't have a good idea that's a valuable trade secret, even if you've never patented anything, that's non-obvious, and even if you've never come up with a trademark or a brand that's completely distinct and unique and, arbitrary and fanciful, or at least suggestive or with some secondary meaning, guess what? We've all taken selfies or pictures on our, I wish I had my camera. Like I took a picture of the sunset yesterday, I took a picture of my daughter earlier today, every time you take a picture, you own the legal rights to your picture. Your profile pic that you submitted to this class, unless you stole somebody's, copyrighted material, if it's your own profile pic, that's yours. If you've written a love letter, to somebody special, or if you've drawn a doodle while you've been bored in my lectures, you've created intellectual property. All the essays that you've submitted so far is your intellectual property. It doesn't have to be commercially valuable. It doesn't have to be new. It doesn't have to be non-obvious. Doesn't even have to be useful. As long as it's original, as long as it's your creation, as long as you get to own the copyright. Now, let me make one clarification. Copyright does not protect ideas per se. It protects expression of ideas. So it's how you express your logo or how you express your idea in the form of a novel. But actually, let me show you. Let's go back to the end of the slide presentation, and I'll have a lot of good examples of this. Okay, let's go into here, and let's go to the next slide with copyright law. You'll notice as early as 2004, February 4th, Zuckerberg has the copyright logo here. It used to be before 1976, before Congress adopted a new copyright law. Man, these busters are just, I've been having to shout. I hope this lecture is coming through clear. I'm just in a real bad spot here because you got some construction inside the house. I'm in a real bad spot. But back before 1976, you could only use the C with the circle if you had registered your copyright. Back in 1976, when Congress adopted a new copyright law, replacing the old ones, you can use the C with the circle or the words "all rights reserved," whether you've registered your copyright or not. Now, eventually, Mr. Zuckerberg and Facebook Inc., they're going to, a Facebook company, they're going to register their copyrights. Google, Starbucks, they're all going to register their copyrights. The reason why you want to register your copyright is because when you register your copyright, it's a lot easier to prove infringement. You can automatically go into any federal court in the country to get your idea, the expression of your idea, your copyright protected. The other advantage of copyright law is you don't have to prove damages. The copyright law has something called a statutory damages table or a statutory damages formula. You get automatic damages, automatic compensation for every act of infringement. All right, man, this is tough. I can't believe these guys here, man. It's like, all right, let's try to power through here. It's just my luck, man. The one day I have to have a class outdoors, these guys are working. All right, how do you get a copyright? Like I say, you can do no registration required. Wait, hold on here. Let me see what's going on here. It should say no registration required. Pardon me, I messed up here. Yeah, registration is not required. Look, all you have to do to get a copyright is come up with something original, an expression of an idea that's original. And here's the key thing. Here's the key requirement. That it be original, that you're not stealing it. You came up with it. And that you're able to affix it or publish it in what the law calls a tangible medium of expression. What this means is as long as you can print, as long as you can draw your idea, print it out, put it on a piece of paper, you can go ahead and copyright it. You know, so it's probably, and remember, the registration is recommended. If your idea, oh yeah, these guys have the blowers now. That's what. Oh man, I cannot deal with the blowers. I wish that shit were illegal. I'm gonna be honest with you.
Professor,
I hate the noise pollution. All they're doing is moving around the dust. They're not even cleaning jack. You know, this has been one of my, you know, in California and Carmel, for example, when Clint Eastwood was mayor, he made that illegal. You could not use blowers without violating the law and getting fined and stuff like that. Anyways, going back to this, so it's probably the easiest of all the forms of intellectual property is copyright law, you know, because as long as you have a way of expressing yourself, you know, whether you draw it, sketch it, write it down. But by the way, look at all the stuff that you can copyright. It's anything that can be basically written down or printed out, including source code, by the way. So source code could be protected by patent law if it's new, useful, and non-obvious, like the Amazon one-click patent, you know. Thankfully, that's now expired, so it's available to everybody. Source code, you know, can also be like the source code, by the way, are the computer programs that go into a website, or it's basically a language of instructions that you give to a computer. Source code can also be trade secret, you know, if it's valuable, commercially valuable, and reasonable steps are kept to keep it a secret. But also source code, source code is also can be copyrighted. And in fact, let me tell you for a fact, that's what the Winklevoss twins did after they brought their complaint for trade secret violation against Mr. Zuckerberg. A month after they brought that lawsuit in September of 2004, they went ahead and copyrighted their source code. And then they amended their complaint to add copyright infringement. And that's the real reason why Zuckerberg settled, by the way. Because as you're about to see, copyright infringement is no joke. All right, this is all the stuff that you can copyright. One of the things, though, that I would like to point out to you that's not obvious is what you cannot copyright, even if it's arguably original, even if it's arguably an expression of an idea, et cetera, et cetera. And one of the few things that you cannot copyright are fashion designs and costumes and things like that. So for example, it's hot out here, so I'm wearing my short sleeve little polo shirt. You know, Ralph Lauren company, they can trademark and copyright the polo logo, right? But the design of a shirt, anybody is free to sell a shirt, you know? So that's what I mean, that you cannot copyright a fashion design, you know, whereas, you know, and this is what, you know, fashion companies do, right? So let's do like Christian Louis Vuitton. All right, let's associate our shoes with this color so we can distinguish our shoes, even if the designs are the same as shoes that you can buy somewhere else, you know, but nobody has the red bottom because that's the trademark, you know? My little Ralph Lauren shirt, even if you can get a similar shirt somewhere else, similar color, etc., you know, only Ralph Lauren can sell the shirt with the logo. All right, I mentioned that because in your discussion post this week, I'm going to be asking whether you can copyright a tattoo design. Let me see if that's the next slide, by the way. Oh, no. All right, let me do a time check. I do want to talk about this week's discussion post. All right, quick timeout. We are now at the end of class, and I've now talked about the four, you know, with all this godforsaken noise, I've been all talking about the four major areas of intellectual property law: trade secrets, patents, trademarks, and copyrights. Just give you a big picture. These are the four areas of the law ideas, intellectual property rights, and this is how you go about getting those rights, whether you register or not. Although patents, you do have to register. That's the one thing that's non-negotiable. Now, what I want to do here is, now you're free to go if you have another commitment, but let me go ahead. I'm going to go on for an additional 20 minutes because what I'd like to talk about now is whether you can copyright a tattoo, which will be this week's discussion post question. And I want to tell you about fair use and copyright infringement, which really stands for a much more important idea in the common law tradition and in our legal environment. So let's go ahead again. If you have to bail, that's perfectly fine. I'm recording the lecture. But if you can stay, I invite you to stay an extra 20 minutes, and I'll then conclude the lecture with the last part. First of all, let's look at our survey results. Let's see what the class thinks, whether you can copyright in a tattoo or not. So I'm going to go ahead and go to the share, and I'm going to go back to my survey, and I'm going to go back to the survey question, which is the last one. Now, the reason why one of the things I like about, and by the way, I don't have a full disclosure, I don't have a tattoo. I'm probably too old for that stuff. But I love this Mike Tyson quote. And it's one of the reasons why, and Mike Tyson's tattoo, I remember when he got that tattoo for the first time, I thought that was the most badass tattoo I'd ever seen in my life. And, and by the way, many of you may have seen the Mike Tyson special. I think it was on ESPN or whatever, 30 for 30, or what Showtime, I forgot what it was on, but it was really good about Mike Tyson's life, his rise to fame, and, his downfall, and how he kind of picked up himself and got back. But one of my favorite things about Mike Tyson is this quote that you're going to see here that Mike Tyson reportedly said very famously, everybody has a plan until they get punched in the face, or everybody has a plan until they get punched in the mouth. And what I really like about that quote is that I think it's probably the single most important quote that you can learn in a business college, in a business curriculum. Because think about like Blockbuster Video. That was the biggest chain, even bigger than McDonald's at one point, and it's completely gone today. There's only one Blockbuster remaining in Oregon, and it only exists because it's just a tourist destination now, think of like RIM BlackBerry. The BlackBerry used to be the most technologically sophisticated smartphone in the world. Do you know anybody who uses a smartphone? A BlackBerry? BlackBerry pretty much went from the dominant player to a nobody, has been replaced by the Samsung Galaxy and the Apple iPhone, right? Think of, I could go on and on. Think of MySpace. Did you know that up until 2008, MySpace had more users than Facebook? In other words, Facebook did not begin to dominate, even come close to what MySpace had until 4 years after the Facebook was founded in 2004. I could go on and on of all these different examples. Also, I can talk about from personal experience. Like right now, I'm getting punched in the mouth by these guys, with the blower and all these noises, you know what I mean? But I gotta be resilient. I gotta move forward. We're gonna have setbacks, minor and big. We're gonna get married. We're gonna have children. We're gonna suffer. Maybe you have to suffer breakups, heartache. We're gonna have a lot of setbacks. We're gonna get punched in the mouth, metaphorically speaking. You always have to bounce back. Having a plan is only so good until you get punched in the mouth. What really matters is coming back from adversity and responding to, rising to the occasion. I think this is probably the single most important business and life lesson I can teach, in this summer A session. Notice here, 40% of the students said, yeah, you can copyright a tattoo, and 60% says you cannot copyright a tattoo. One of the things I can tell you as a sort of a heads up, a big hint, this is still an open legal question. In fact, although there have been some cases raising this very question, including the Mike Tyson, the famous Hangover Part 2 case, all of these cases got settled out of court or are right now on appeal, like the Electronic Arts NBA player and college athlete case, whether you can, do you need a license to portray somebody else's tattoo? Well, that's going to depend on whether you can have a property right to a tattoo design. Now, I'm going to tell you something that this is an open legal question. So there's no right answer as of today. This is the other reason why we have courts, right? Because sometimes, you could argue, no, a tattoo design is like a fashion design, and you can't copyright a fashion design. Why should you be able to copyright a tattoo design? Or you could argue that as a matter of public policy, we don't want to have, think about you don't want to have property rights on someone's skin, that comes maybe a little bit too close to the era and the system of slavery, in a metaphorical sense, maybe that's just not, that's pushing it. You know what I mean? So maybe we don't want to go down that road, you know? Maybe it's just open up a big Pandora's box. If you style, like, for example, Carmelo Anthony, Portland Trailblazer, right? He has a tattoo of the Warner Brothers logo on his skin. You know, is that a copyright infringement? Can you get can you get a court to make him remove it? That kind of thing. Maybe we don't want to make this, we don't want to, get the law involved in this type of thing. On the other hand, those of you 40%, which I'm inclined to agree with, I'll be honest with you, all the copyright law says, going back to the common law tradition, is as long as your design is original, right? And as long as you can affix it on a tangible medium of expression, and presumably human skin is tangible, right? Then why not? Why can't you copyright a tattoo? Why not? Now, I will tell you one of the ironies of the Mike Tyson tattoo, and I don't want to get into too hardcore into this, but if many of you are like art, like I do, and I'm a very much an how do you call it, a Maori file. I love the Maori culture of New Zealand. I find that very fascinating. This was before the Europeans colonized New Zealand. New Zealand was, it belonged to the Maori people, and the Maori people, one of their famous things are their beautiful tattoo designs, really intricate. And ironically speaking, the Mike Tyson tattoo is actually inspired by, maybe even a direct copy of, a Maori warrior tattoo. It was a warrior culture. And so that raises really interesting issues of cultural appropriation. Can you, is that really original then? Can you copyright the design of that belongs to an indigenous culture? Your Abraham Zapruder, can you copyright, what is evidence of a murder? Those are really, really, I will tell you, in the Zapruder case, courts have said that, yes, you can copyright that. And that means, the copyright owner decides who gets to see the movie and how much to charge for it. Very controversial, in my opinion. Now, subsequent to those legal decisions, the Zapruder family has donated their copyright in the film to the Daley Plaza Museum in Dallas, Texas, which is located on the Texas School Book Depository building on the 6th floor, where allegedly Lee Harvey Oswald assassinated President John F. Kennedy. If you are in Dallas, I cannot recommend strongly enough that you visit this museum and you learn about this part of American history. It's one of the most, to me, I'll tell you, it's one of the most fascinating events in American history. And I'll talk more about these lawsuits in the next class. All right, so let me end here. What I want to end here is, let me go back to the slide presentation. And then I do want to talk about copyright infringement and then end the class on this, because this is, there have been some laws enacted since 1976 that are very significant, and I want to share those with you. So if you'll allow me to go into the copyright presentation here. I forgot to put this on the survey, didn't get saved, unfortunately. But you could make a strong case, if you look at my modules, I've shown you a bunch of film clips, I've shown you a bunch of Harvard Crimson articles. I've shown you a bunch of copyrighted materials. And rest assured, with the exception of the Harvard Crimson, because it's part of a book project I was working on, I did not bother. Like when I played Usher today, sometimes I play Fat Joe, Lean Back. I was also a big hit in 2004. And Lean Back, I actually like that song even more. But I'm not going to get permission from Sony Records. I don't have time for that. They want to come sue me, that's fine. You know what I mean? I'm going to argue it's fair use. So let's talk about copyright infringement, and let's talk about. By the way, you won't need to know this but I want to let you know that when we talk about infringement, it's actually a very important issue, because there's not only direct infringement, where you yourself steal somebody else's, like Zuckerberg did with the Winklevoss twins. There's also indirect infringement. And the most famous example of this is going to be the Napster case. And because I know for a fact, all of us, whether you like the hip hop music I play, or whether you like, country, Western, whether you like, classical music, or whatever you like, I know we all love music. And Metallica is this really successful heavy metal band, but they spawned a lot of controversy when they sued the Napster. Napster was, if you saw The Social Network, do you remember they made such a big deal that the Facebook got a million users by the end of 2004 or early 2004. And that was a really big deal. And in fact, let me tell you, that is a big deal. I think Twitter and YouTube, it took them longer to get their first million users. You know, it takes a long time to build up a user base. Facebook did it in under a year or about a year. Well, Napster, you want to know how many users they got about a year after they were founded? They got 26 million users, mostly college students. So now I know we don't use iPods. I know we don't use Napster or anything like that. But, you know, back in the day, you know, you had two choices. You could pay $20 for a CD just to listen to one good song, Lean Back, if it's Fat Joe and the Terror Squad, or, you know, Usher, you know, yeah, or whatever, you know, or, you know, 50, you know, you want to listen to is that In the Club song, you know, you pay $20 for a CD when all you care about is that one song. Or before Apple iTunes came along, you could just download the stuff illegally off Napster, you know? And so, of course, most people prefer just to get the stuff illegally off Napster, you know? Although I want to prejudge whether it was illegal or not because, you know, at the time, the case hadn't been decided yet. What happened is, and I'll tell you, this is really, really interesting. I don't know if you're a big fan of, I'm more of a big fan of the Bourne Supremacy franchise, but, you know, Mission Impossible 2 is pretty good. I'm not a big Tom Cruise guy. I think he's a little bit smug and presumptuous. I'm more of a Matt Damon, you know, but it doesn't matter. You know, they're both good shows. And I love the Mission Impossible theme song. But what happened is Metallica recorded the theme song for Mission Impossible 2. And that movie was set to be released on Memorial Day of, I think it was, I forgot what year it was, but back in the, you know, when Napster was just founded. And what happened was that people were already listening to Metallica's Mission Impossible theme song before the soundtrack was officially released. And so Metallica hired some private detectives and investigators, and they did their research, and they found out that, you know, somebody had posted the song to Napster. And that's how people were downloading, you know, because Metallica is a very popular group, band. And so, and I got to tell you, the way Napster worked, it was pretty much the way YouTube works. You sign up for Napster, or you open up a YouTube account, and when you opened up, actually Napster worked a little bit different. When you opened up a Napster account and you downloaded the Napster app or the Napster program, back then there were no apps, there were no smartphones, but when you download Napster to your computer to be able to access Napster files, what Napster would do is that Napster would be able to access your music files, but that was saved on your computer. But in exchange, you would be able to access the music files of every other Napster user. So that's how Napster grew and became so popular. I mean, it was even more popular than Facebook until, that is, Metallica sued and got Napster shut down. Now, oh, by the way, let me, I'm going to go back to fair use. Well, actually, let me go back to fair use, and then, well, because I want to wrap up this lecture. What's really interesting about the Napster case is when Metallica won, then the Recording Industry Association of America brought suit, same lawyers as Metallica, and then they sued on behalf of every other, you know, every other music producer and music composer and every other artist that owned their own songs and stuff like that. And by winning their case, what happened is the courts effectively shut down Napster. Now, I want to take a time out here just for a moment because, and do a stop, and I want to blow this up because I want to show you, this is actually, you know, when you think about it, for a judge, a court of law, to shut down a business that has 26 million users, that is a big deal. That is a huge deal. And this is why, you know, I say copyright infringement is kind of a big deal. You know what I mean? And the theory was that, you know, Metallica's theory was that Napster, by making the music files and making it easy to do peer-to-peer file sharing, they were engaged in indirect infringement or contributory infringement, you know, so Napster was on the hook, you know, and I have to tell you that, you know, for a court, I mean, you know, it's one thing for, you know, there's a revolution in Cuba and the government comes in, Fidel comes in and he takes over all the businesses, shuts them down or takes them over. It's one thing for a court in a capitalist economy to come in and shut your business down because you allegedly are a copyright pirate. So, you know, that's kind of a big deal if you think about it. You know, you stop to think about it. Very extraordinary remedy. So let me explain what happened in that case, and I'll do this by then doing the last part of my screen share. This is what happened. Napster tried to say, no, wait a minute. This is fair use. I mean, think about it. Why is YouTube legal? Now, YouTube wasn't open until 2005. I mean, YouTube wasn't launched until 2005. But, that's going to be like the fair use. Hey, we're, people, people are just listening to the music for legitimate purposes. You know what I'm saying? This should be a fair use. Here is the problem with fair use. Fair use, if you remember my last lecture where I talked about the common law and how the common law is divided into standards, general, flexible standards, and bright line rules. Fair use is a great example of a general standard because it's composed of 4 factors. And what are the 4 factors? They're right there in this slide. The courts are going to ask 4 questions. And forget about Napster, because I think Napster's an easy case that they were not engaged in fair use. But what about me, the professor? When I show a clip from the social network, or when I show, like I took some pictures of the Tiger King and put them in module B. I took some stuff from Facebook's homepage, put it in module C. Is that fair use? Or am I a copyright? Am I as bad as Napster? And I could get shut down. Well, first, you look at the purpose of the use. And that, of course, is going to be my best defense, right? That I'm going to argue that all this stuff is educational, Now, you may not believe me. You could argue that playing music and, playing Fat Joe, what does that have to do with education, But I'm going to argue that it's educational, And I'm going to argue that showing you all this stuff and setting up the stage, getting us back to 2004, all of this stuff is educational. So assuming you buy or a judge buys that argument, I'm good there. The purpose of my use, when I show you materials for which I haven't got copyright infringement authorization, copyright authorization for, I'm going to argue it's not infringement because of fair use, purpose of the use. I'm doing this for educational purposes. Notice other fair use under the first standard are, for example, news reporting or parody. So Saturday Night Live, if you're a big fan of SNL like I am, they'll make parodies of actual products and actual people, right? And the idea is they're saying, well, this is our First Amendment right, but here's the deal. Here's the deal. Just because I'm using this stuff for educational purposes, quote unquote, doesn't mean I win. That's only one of the 4 factors. Look at the other 3 factors. Nature of the work that's being copied without authorization. Am I copying something that is really meant to be in the public domain or is really meant to be shared, like maybe the Zapruder film? I would argue that the Zapruder film is something that all Americans need to see because you need to decide for yourself whether the Warren Commission and the government lied to us or not, So I would argue there's a good fair use in, even if I don't have authorization to show the Zapruder film, I should still be able to show it. Now, of course, it's a moot point because it's been donated to the museum and the museum has decided to make it public, but back in the day when the Zapruder family owned the film, it was not so easy. You had to get their authorization or pay a fee. So the nature of the work. Now, admittedly, all the stuff that I'm sharing with you is pretty much, commercial stuff. You know what I'm saying? But, I probably lose on the second factor. What about the third factor, amount used? Notice here, it's a flexible standard, right? The more you use of somebody else's work, the more likely you're going to be found in copyright infringement. The less you use, the less likely. But it's a sliding scale. There's no hard rules, right? So in my case, like if I were to show the entire Social Network movie, I'd probably would be committing copyright infringement, to be honest with you. It's a commercial movie. It's available on Netflix or the Columbia Pictures. They would have every right to sue me because even though I could say it's educational purpose, but it's a commercial work, or it's a motion picture, Hollywood blockbuster, and I'm showing the entire movie. What I'm really showing, though, are just a few film clips. So I'm probably good there. So maybe I win on factor number 3. Look at the 4th factor. What is the effect on the market of your stealing, of your theft, of your piracy? If your effect is to destroy the market, for the copyrighted work, I'm going to tell you, probably the other factors don't matter. If, on the contrary, the effect is to expand the market for the copyrighted work, right? Then probably you're going to get off scot-free and it's going to be fair use. Now, one of the maddening things about fair use is that the courts, I find this frustrating as an attorney. I was an IP lawyer before coming into here, and I still do stuff, is that the courts don't weigh this. They don't say it's just 25. Are these all equally weighted? But I will tell you, in my experience, it's that fourth factor that does a lot of heavy lifting, you know? And it's probably why, in my case, I'm actually expanding the market for the social network, for the movie JFK, for the Tiger King series, because I'm inviting you to watch those movies. And maybe some of you have subscribed to Netflix or have, you know, downloaded those movies through Amazon Prime or whatever, you know, so I'm expanding the market. I'm not destroying the market. Look what Napster did. Look what Napster did. Napster, look at what happened to the market for CDs, right? As soon as Napster came on the scene in the early 2000s, right? Napster crushed the market for CDs. I mean, you see it right then and there. By the way, if I can take a time out, I know I'm over the time limit, but I want to share with you what is one of my favorite scenes of the movie, The Social Network. I'll share with you another of my favorite scenes in the next class. But one of my favorite scenes, and I won't do a share screen to save time, but one of my favorite scenes is when Justin Timberlake, who plays Sean Parker, co-founder of Napster, is when he goes to meet Zuckerberg and Eduardo Saverin for the first time. This meeting actually happened at the restaurant where it was filmed. It's called 66 in Tribeca. And Sean Parker's going on and on, Justin Timberlake is going on and on about how he destroyed the record industry, you know, and how he, you know, revolutionized the music industry. And then Eduardo Saverin, Andrew Garfield, right? He says to him, but wait a minute, you lost the lawsuit, you know, in fact, your business got shut down, you know? And then Justin Timberlake, and what I think is one of the best lines in the movie, says, you want to buy Tower Records, Eduardo? Tower Records used to be like Blockbuster Records. They were a chain of stores where you could buy music CDs. And of course, when Napster basically destroyed CD sales, right? Tower Records went bankrupt, you know? Now, you can see that under this fourth factor, Napster had a very negative market effect, right, on the music industry. And in a way, Sean Parker or Justin Timberlake was right. Look how the music industry, right? God, I can't believe this noise has been going on since I started the class at 1:30. Look at this here. Look what we have here. We've got the music industry got punched in the mouth by Napster. They sued Napster, beginning with the Metallica lawsuit and the Recording Industry Association of America lawsuit. And then the music industry, even though they won the lawsuit, they still had to change their business model, because would you still rather pay $20 for a CD or 99 cents for an Apple iTunes for the one song you like, the Fat Joe song that I like, you know? Or would you just rather go to Pandora and Spotify? You know what I'm saying? And by the way, look at this streaming remedies. That's the Pandora and Spotify. 1/3 of the music industry, and now it's actually more. This was from 2015. And I apologize, I haven't gotten the more recent one. This is when I started teaching this course at UCF. But here's the deal, that now the music industry makes most of their money, not from the sale of CDs, though they still make some money from selling CDs and vinyl records and even some cassettes and 8-tracks. They now make most of their money either from downloads, which back in the day when you had the iPod, or today from streaming from Pandora. What it is that Pandora allows you to listen to the songs for free, or Spotify, but they pay a royalty to, they pay a fee to the to the record industry. Of course, you can get a subscription service and avoid all the ads, and some of that money also goes to the record industry. So, you know, there's a lot of different ways. Basically, the record industry got punched in the mouth, and they responded. You know, even though they won the lawsuit, they still had to change their business model. So this is one of my favorite examples. All right, there's one last thing I want to talk about, and this is important for you, because if you're like me, you use the internet a lot. And if you're like me, you're stealing, quote unquote, a lot of stuff from the internet, or creating markets, so maybe it's fair use. But I want to share with you one last question. Why was Napster declared illegal and shut down? under the fair use, you know, was not fair use. And why is YouTube fair use? Like, why is YouTube? It's basically the same business model. If anything, YouTube is worse because with Napster, I actually had to download and get the app. With YouTube, I don't have to sign up for YouTube in order to access all of the videos that are available on YouTube, many of which are copyright protected, right? Well, let me explain to you 4 words. 4 words to distinguish YouTube from Napster. If you want to know why it is Napster, one of the most successful all-time startups before they got shut down by the courts, 26 million users in a short time, why they were shut down and declared an outlaw business, and why YouTube is worth billions of dollars and is now owned by Google. 4 words: the DMCA, or Digital Millennium Copyright Act. Now that's a mouthful, so I'll just say DMCA for now on. But this law really affects our daily lives today. So let me explain how the law works and why YouTube is illegal, completely legal, you know, completely on the right side of the law, whereas Napster found itself on the wrong side of the law and could not invoke the fair use defense. I want to give you an example. I don't know why do I have this here. Sorry, I don't know why this is the I'm sorry, this is the Google patent. This is out of place. I apologize here. This is a mistake. There's every page. So let me just go ahead and just continue. And this is basically what I'm asking, you know, why isn't YouTube guilty of copyright infringement? Now I forgot this did not get included in the survey by accident. So let me just go and explain. Oh, okay. So the slide. So I completely got slammed here. I apologize. I'll just explain it in words. Let's go back to the DMCA. The DMCA does 3 things, and it explains why YouTube is legal, why Napster was illegal, and it has nothing to do with fair use. What the DMCA did, let me simplify for it. It did 2 things. The law was enacted in 1998, and what the law says is, first, what it does, it says, you know what? We're going to extend intellectual property rights. We're going to extend specifically copyright law to the internet. So before 1998, it was actually an open legal question, much like the question, can you copyright a tattoo? It was an open legal question whether, if I take a screenshot of somebody's work on the internet, on a website, am I infringing their copyright? Because that's on the internet, you know, that's kind of like intangible, you know, physical medium. Is that copyrightable? You know, that was an open question. And the courts weren't in agreement whether that was illegal or not, you know, regardless whether it was fair use, you know. And what happens is the DMCA says, no, guess what? We're going to protect copyrights on the internet. And unless it's fair use, it's going to be, you know, if you take someone's borrow or take, you know, or screenshot or scrape, or even include a link that has access to copyrighted materials, that will be technically copyright infringement. But here's the difference. Here's the second thing the copyright law does. It says now, in order to enforce your copyrights online, on the internet, before you can sue somebody for copyright infringement on the internet, you, the copyright owner, have to send the infringer or alleged infringer, because it might be fair use, right? You have to send the alleged infringer a takedown notice. And the idea with the takedown notice is basically it's a compromise. You have to give the infringer a reasonable period of time to voluntarily take down whatever the infringing copyright material is before you can sue them. If they don't take it down voluntarily, then you can sue them in court. And if it's a federal registered, you can go to federal court and get automatic statutory damages. If they do take it down, then you've lost your right to sue them. They've taken it down. We don't need to go to court. That's why I say it's a compromise. And by the way, before I explain why it's a compromise, think about this, right? This is why YouTube is legal and Napster was declared illegal. When Napster got the takedown notice from Metallica, and by the way, they were also sued even before Metallica by Dr. Dre. When they were sued by these musicians and artists, they took the takedown notice and they flushed it down they flushed it down the toilet. They tore it up into little pieces. They completely disregarded the takedown notice. They didn't take anything down. So when they got to court and the court saw the statistics, They saw that it was a negative market effect. Boom, they're going to lose. There's no fair use. It's outright infringement. Peer-to-peer file sharing is outright infringement, direct and indirect infringement. YouTube, though, is different. Look at the screenshot I have here, right? YouTube, when they get a takedown notice, right, they'll take stuff down, and they'll take that stuff down immediately. And in fact, YouTube has actually algorithms. Sometimes they don't even wait for a takedown notice. Sometimes they will just take it down automatically. And, just to avoid even having to get a takedown notice and, and just be as safe as possible in terms of not violating the copyright laws, Now, I will tell you, one of the things I like about YouTube is that if you ever get one of these notices on YouTube or on Google Images, if you see, oh, this image is no longer available. What I like about Google, even though Google, I don't know if they're still that kind of good company. I don't know if they've become, we'll see this in the last module, are they still a good company? Are they still morally, ethics and all that? But one thing I do like about Google is they're pretty transparent. They'll include a link taking you to the takedown notice so you can see for yourself why it was taken down and who asked for it to be taken down. So that's the big difference, that under the DMCA of 1998, Congress modified existing copyright law in order to make it, to extend copyright law to the internet, but to provide a safe harbor, the takedown notice system, takedown notice mechanism, before somebody could get sued for copyright infringement on the internet. The reason why, and I'll end on this, didn't do Q&A, but I'll end on this on the formal part of the lecture. The reason why this is such a compromise is because, think about it. Now it's up to the copyright owner, the Hollywood movie studio, the TV production company, the record label, right? The publishing agency in New York City. Now it's up to the intellectual property owner to spend the money to hire the people to police the internet to find out, okay, well, who's posting our stuff illegally? And even after, excuse me, you hire all of these people to find out who's posting your stuff illegally, you still have to go and send the illegal alleged infringers, a takedown notice and give them an opportunity to comply before you can sue them. So think about it. That's why I call it a very fortuitous compromise. I will tell you, back when I started teaching this course in 2015, there was something called the Stop Online Piracy Act that Congress was considering, and it almost went to a vote in the House and the Senate. You may recall, many of you would have been 5 or 6 years younger, so you may have been in middle school, but you may recall that one day Wikipedia went dark. They went completely offline for a single day. You may recall that Google put like a big piece of like black censorship tape on the Google logo for 24 hours. And what was happening, all these companies were protesting the Stop Online Piracy Act, because what the Stop Online Piracy Act would have done, had it been enacted, it would have gotten rid of the takedown mechanism. It would have said, you're automatically guilty of copyright infringement the moment that you share stuff on the internet without authorization. There's no need anymore to send a takedown notice and to spend all this money to police the internet, So I'm going to tell you something. If you're like me and you use the internet, I may be an old guy, but I use the internet a lot. And I like the way the internet now is pretty much free and I can share stuff without having to get permission. And I'm going to tell you, keep an eye on your member of Congress. Keep an eye on these politicians, because the last thing you want them to do is to enact, some kind of, Stop Online Piracy Act, new version of the law, basically, getting rid of this compromise that was established in 1998. I mentioned that because that would affect us directly, And as you saw with fair use, it's not easy to prove fair use because you have the 4 factors, it's a general standard. All right. With that, I'm going to go ahead and close this part of the presentation and open it up to question and answer. Now, with my TAs, are there any questions or concerns, comments that I should address from the chat, or have we addressed all those to everyone's satisfaction?
So far, there are no other questions that I'm seeing in the chat right now. I think everything has been answered.
Wonderful. Yeah, I see the chat. I see the chat was pretty active, so that's good. Thank you so much for that. Like I say, any other than questions, comments, or concerns, and then we can call it a day. The main thing is you now know with today's module there are 4 major areas of intellectual property law. You now know that all of us in this virtual room have created some form of intellectual property, most likely some type of copyright. The moment you write an essay or take a picture or whatever, write a poem, love letter or something like that, that's your copyright. You own that, whether you register or not. So as you can see, it's a very involved area, but I want to emphasize how important intellectual property rights are, so that when you go into business, some of you I know from the introductory academic activity, some of you want to start your own business, you should really be thinking of, okay, I need to have a good idea for my business and how can I protect it? The last thing I'll say, I'll end on this. There is a film clip in the module C. It's a short interview or a preview of an interview with Peter Thiel. Peter Thiel is a very controversial figure. Although he helped finance this Gawker lawsuit that Hulk Hogan brought that ended up closing Gawker. This was a very big controversial lawsuit. He ended up, he's one of the investors in this company called Palinter, which is like this facial recognition being used by the police. Very controversial. I know the pros and cons, but it's controversial. He's also the first investor in the Facebook, as the movie shows you. But what's really interesting is in this film clip, he explains why it is he invested in Facebook. And he explains that, it's not just enough to have a good idea. You have to figure out how to, he calls it the X, it's not enough to have a good idea in business. You have to have a method of making money off of your idea. He calls these 2 variables X and Y. X is having a good idea for a business, and Y is, okay, how do I make money from my idea? Well, what Peter Thiel doesn't tell you, that I tell you, is this: the way you make money, or one of the ways, and I would say probably the most effective way you can make money legitimately, honestly, lawfully from your ideas, is through intellectual property law. Intellectual property law is how you assert ownership over either your ideas with trade secrets or patents, or the branding of your product, ideas, products and services, or the expression via copyright law of your ideas and whatnot. So this is why IP law is so important, whether you're an entrepreneur, going on a Shark Tank show or something like that, or whether you are a big player like Amazon or Google, and you want to expand your business or maintain your market share. Well, you do that by developing ideas, protecting those ideas, or buying the rights to the ideas that other companies have developed. So it's what's really interesting, and I'll end on this note. One of the co-founders of Instagram was this guy, a young kid, like he was in your position, just out of college. And I know many of you are seniors from the introductory assignment. And he started, he actually interviewed to go, he wanted to work at Facebook. Now you have to understand, this was in 2009 or 2010. This is when Facebook was still a cool company, much like maybe TikTok or Snapchat. Those are still kind of fun, small, cool companies, although there's some controversy with TikTok and the ownership structure there. And, but here's the deal. Brian Acton got rejected. He had an interview with Facebook and he never got hired, and what did he do? He turned around, and with a group of his friends, they said, well, I can do something better than Facebook. I'm going to show these guys that I can do something not just as good as Facebook, but better. And he created the original Instagram. And if those of you know Instagram has gotten, I think, a lot worse over the years, in large part because of what Zuckerberg has done to Instagram. But the original Instagram, had basically no ads, a very simple, clean site, and it was a really fun site. And what's interesting is that 2 years later, right, Facebook, Zuckerberg is going to pay Brian Acton $5 billion for the rights to Instagram. And think about that, right? Acton got punched in the mouth when he didn't get that job. That was his number 1 job choice. And this, like I'm saying, life doesn't always go our way, but he bounced back. In his case, he did his own thing, and he ended up having the last laugh. You know what I mean? He ended up selling his company for $5 billion. And that's I'm impressed at that. And even Mark Zuckerberg, who I'm not really a big fan of, in the whole Face Mash episode, I will tell you, right? He's done a lot of great things, if you think about it. And so we have to sort of blend the good and the bad. And one of the good things that Zuckerberg did was to launch this website that at the time was a very popular and useful website. Maybe today less useful. If you recall from our week 1 survey, week 2 survey, very few people now use Facebook as their primary social media, but it's still a backup in many cases. All right, great. I think that's it. Let's go ahead and call it a day. I've gone way over. I do, apologize. Part of it is this so-called real format, where I only have 6 classes, but now you have a good grasp of IP law and why it's important. All right, so take care. God bless, and charge on.